I'm Arnold Loewy. I'm the George R. Killen Professor of Criminal Law at Texas Tech School of Law. I'd like to tell you about my casebook, Criminal Law Cases and Materials. It differs in several ways. In one particular, after each case, there's a series of focused questions and notes so that the students have an opportunity to think about what they're going to be asked in advance. And the professors know they have had the opportunity to think about it, and hopefully the students' answers are going to be more thought out. Another difference is the ordering of the material. I've actually gone back to an earlier day where students talked about, or the course talked about the specific crimes before it focused on mens rea and actus reus. Now, I view mens rea and actus reus as the central features of the criminal law, but I also think they're terribly esoteric in the abstract. If the students have already learned about homicide, rape, theft, kidnapping, etc., then when we get to talk about mens rea and actus reus, we're essentially reviewing things that they already knew. And when we talk about extraordinarily difficult concepts like specific and general intent, we can point to specific illustrations such as the intent to permanently deprive in theft, the premeditation quality of murder, and that sort of thing. And as a result, I think it comes across more clearly to the students than would otherwise be the case. So the ordering is one difference. The questions are another difference. And the effort to have about the number of classes there are in the total number of hours available, which I spell out in the teacher's manual, is the third difference. This book can be adapted to either a 3 or a 4-hour course. It was originally intended for a 3-hour course, which many criminal law courses are. In the original edition, there were only 44 classes. But because I've added a few sections like statutory interpretation in the Supreme Court, assisted suicide, juvenile criminality, and the like, it's now up to a total of 49 hours, which means in a 42-hour class you have to cut 7. I have my own favorite to cut, but you do have to cut 7. If you have a 4-hour course, and a number of law schools do, then there's actually 7 extra classes that aren't covered, which, trust me, will work well. My students tell me I shoehorn a little bit too much in. So if you have 56 hours to cover 49 classes, you can cover the entire book, and some of the classes you can overlap or essentially take 2 hours to teach what I say could be taught in 1 if you push it. So I think it works pretty well for a 4-hour or a 3-hour class. I recommend that the students read some basic text in criminal law so that they essentially will know the law, know the basics of the law when they come in. I don't want to spend valuable class time focusing on things they could pick up on their own relatively easily. So if they've read a basic text and that's relevant to the material, come in with that understanding, then that makes it a lot easier to focus on the analysis that the courts used. They're able to see better when defense lawyers haven't made the right argument, when judges seem to be off base or different from what other judges do, and they can see where mistakes are being made, so that hopefully they are not going to make them when they go out into practice. And I don't think most case books do that. I want to underscore how important I think the book is in terms of developing students' thought processes. I don't think that's something which is typically done. I think more typically books seem concerned with conveying material. This book, I think, will make the students more critical thinkers and hopefully better criminal lawyers by virtue of having used it. If you'd like to contact me, I'd be most happy to hear from you and most happy to help you with any questions that you might have. So please feel free to do so.